Hello, everyone, and welcome to another Darrow webinar. Today, we're going to speak about ERISA litigation. And before we start, I'm just going to give it 30 more seconds for everyone to join. Great. It's good to see familiar names and new names. Welcome, everyone. I think we can start. So welcome everyone to another Darrow webinar. My name is Amit Chemish. I'll be your MC for today. And we're here to speak about ERISA. Today's webinar is about ERISA defined benefit litigation, and we're going to talk about the recent monumental Colgate $300 million settlement and what it means for the future of ERISA litigation and how it's actually possible to find more violations of this nature. Now, before we dive in, I'd like to introduce you to our speakers today. Fantastic. So I'm joined by two of my wonderful colleagues. We have Jordan, who's part of Darrow's litigation consulting team, offering both strategic advisory and legal support to Darrow's partners. Jordan was admitted to the bar in 2016 and clerked at the High Supreme Court of New Zealand. He also has experience in litigating complex matters in the country's top commercial practice. We also have Lior. Lior is a senior data scientist here at Darrow, where he works on bridging legal intelligence with R&D. Lior has a PhD in biomathematics with expertise in AI and machine learning, as well as 15 years of experience spanning a number of sectors, including biotech, defense, and education technology. So really setting the stage for a very interesting conversation. Now, before we move on, I just want to frame today's discussion by showing you a newly discovered legal risk that Darrow has sourced. For most Americans and truly most people in the world, a pension is not just a number on a piece of paper. It's really a promise of security after many hard years of working. And the truth is, and we see it here at Darrow and in the Colgate litigation, is that sometimes this promise doesn't come true. Darrow has recently discovered an ERISA violation with approximately 20,000 victims with north of 200 million damages. This is a large US company with defined benefit pension plans that promised a retirement income based on years of service. And at the end of the day, the compensation was just not there. So Darrow's analysis, which we will get into later, shows that the plan fiduciaries were relying on actuarial assumptions that have not been updated in 70 years. Now, let's just take a second to try and imagine the world 70 years ago, what the life expectancy was, and how we saw our lifespan within the workforce. Clearly very different, which means that most of these pensions being based on information from 70 years ago are simply irrelevant and don't reflect modern life at all. Um, at the end of the day, the result of this is that there is significantly less compensation than what the people of these pension plans should receive in 2025 or in this day and age. And what I want to talk about today and what Jordan and Lior will talk about is one, the nature of these violations and the precedents that exist within this realm, and then how technology can help you spot these type of cases, litigate them better, and really lead to results that change the workforce and make it a better place. And with that, I'll hand over to Jordan.
So thank you, Amit. It's a pleasure to be here. My name is Jordan. I'm a member of the legal consulting team here in Tel Aviv. And I'm here to talk about a really, really interesting piece of litigation that has just settled in courts, reaching a monumental settlement of $300 million. And of course, this is the Colgate case. Now, I know that most of you will be broadly familiar with this case. So rather than going into all the details about the procedural history and the facts, today I want to focus on what this really means in a bigger picture level for our profession, for the plaintiff's bar, and for the broader landscape of large-scale benefit plan litigation. And I guess for me, this settlement really isn't just about a pension formula. It's a proof of concept, and it shows that persistence, precision, and class-based strategy can move even the biggest defendants to nine-figure outcomes. But all that said, I think I need to be very clear at the outset. The background to this case is very unique and kind of peculiar. The violations arose out of a very particular set of circumstances, with the core of the dispute centering on specific language in Colgate's 2005 residual annuity amendment. It's purported to be retrospective, and this document might have never ever come to light had it not been stumbled upon by eagle-eyed counsel during other ERISA litigation against Colgate. And although that attorney had really deep institutional knowledge from the years of prior litigation against Colgate, this whole legal theory about residual annuities had never been litigated before. So while we're going to be discussing the broader implications here, we need to be realistic about what is and what isn't generalizable. That said, I think it's easy to believe that other companies have these kinds of drafting and implementation issues around residual annuities or other benefits. And as I'll discuss shortly, I think the question isn't whether these violations exist, but actually, how can we find them? And this, I think, is what makes this case such an important proof point. And this is what makes the technology discussion that follows so relevant. But before I get into that, I want to pause and reflect on the human side of this case. Because at its core, ERISA litigation is really about people, not just numbers. It's kind of easy to get lost in the scale of a $300 million settlement, or in the technicalities of actuarial tables and plan amendments. But every dollar in this settlement, or in any ERISA settlement, represents a real person. A retiree, a spouse, a family, an American worker who was counting on their pension being calculated correctly. And for these individuals, the underpayments aren't just abstract accounting errors. They can mean real, tangible hardship. And it's not hard to imagine how this could look. Retirees having to delay long-planned moves because their lump sums were less than expected. Widows struggling to make ends meet because her survivor benefits were not calculated properly. Or families having to make difficult decisions about healthcare, housing, or supporting grandchildren, all because of a shortfall that on paper and in the scale of a large corporation might seem small, but in reality makes a world of difference. So as we talk about the legal and financial impact of these cases, let's not lose sight of the human stories that lie beneath them. And for me, this is what makes this work meaningful. And it's why these victories matter. So let's take a minute to talk about just how huge this settlement is. And when I say huge, I mean that in every sense. Firstly, financially, just $300 million in the ERISA space is just enormous. As far as I know, it's the biggest ERISA settlement we've ever seen. And what's more, the ultimate settlement agreed in this case represented almost 98% of the total residual annuities claimed, with the parties explaining to the court that the small 2% difference represented the possible risk and delay of Colgate seeking to appeal a key Second Circuit judgment to the Supreme Court. This level of recovery is absolutely outstanding. And it's a testament to the party's determination, or to the plaintiff's determination, that it reached this level. And more on that point, legally, the plaintiffs overcame multiple dismissal attempts and appellate scrutiny. And that's no small feat. From memory, I think there were 14 defenses raised by Colgate, and those defenses would have either eliminated the claim in its entirety or would have reduced the potential value of the case to a small number, around 12 million. This shows us that with determination and really laser-like attention to detail, the defense playbook of delay and procedural attrition and appeals, it's not guaranteed to protect them from liability. And lastly, just on a symbolic level, this settlement for me reaffirms that employee benefit miscalculations, even when buried under actuarial tables and thousands of documents and fine print, it shows that when these cases are discovered, they can be very successful. So this litigation, or sorry, the broader litigation against Colgate has been around for nearly 2 decades. And with this particular residual benefit litigation being around for around 9 years. And the fact that it ended with a $300 million settlement broadly can tell us three things. Firstly, it shows us that this highly technical, document-specific ERISA claim, not depending on interpretations of the ERISA statute or anything like that, but this very tailor-made litigation can carry real financial weight. If one plan has this many issues, it's likely that others too. And flowing on from this point, while each case will be document specific, I don't think that this necessarily means these cases will be rare. It's pretty likely that major plans will have been amended a few times over the decades, and every amendment will create new ambiguities. It will create new interpretation questions and also room for error in implementation. And I think these document implementation disconnects are probably more common than we think. They can just be very, very hard to find. And finally, the sheer duration of this case highlights the determination required and the importance to have a lot of confidence in what you're doing. But it also shows us that when plaintiffs' attorneys are organized and they have evidence on their side, then time is also on our side. But there is one other learning I want to discuss, and this is the importance of expert testimony and data analysis. In these cases, we have to be candid that they are not won on legal theory alone. They rely heavily on expert analysis, actuaries, and data scientists. These people aren't just supporting players. They're both essential to proving to the court that the violations are happening and quantifying the harm, but also in helping us attorneys understand that there might actually be something here to look at in the first place. You need to analyze years, sometimes even decades of plan data to reconstruct benefit calculations and demonstrate the patterns that might otherwise remain hidden. It's not enough to just show a single error. And in the Colgate case, the plaintiffs spent nearly $2.9 million on experts over the 11-year duration of the case. That's including the pre-filing investigation. That is a huge investment. And it's one that certainly paid off in this case. Without the expert analysis, the underpayments might have never been discovered, and let alone proven on a class-wide basis. But today we also have new tools. And I think these tools mean we can be more systematic and more efficient, certainly at the early stages of case investigation and litigation, when assessing in particular whether there has been a violation. Advanced data analytics can identify calculation anomalies. Natural language processing can analyze plan documents for ambiguities, and machine learning can spot implementation patterns. And I think this is a reminder that as ERISA litigation evolves, so too must our methods. Of course, our legal acumen is still vital, but needs to be paired with technical fluency and a willingness to dive deep into the data. And for me, the lesson is clear. I think the future of ERISA litigation means building interdisciplinary teams, investing in analytics, and being prepared to engage with the numbers as deeply as we do with the law. So what's next? I see Colgate as a signal flare for a broader wave. This combination of technology, transparency, and public demand for accountability means that these types of cases can grow. But also, time is of the essence. Defined benefit plans are no longer widely used, and the beneficiaries that do exist are getting older, and they're needing their pensions more. It means that there is a potentially finite pool of these types of cases. And although that being said, following Colgate, we believe that there are other violations out there to be found. Yes, each plan is unique, but thousands of defined benefit plans exist, each with decades of amendments and complex implementations. Document specific doesn't mean rare. It means we just need systematic ways to analyze the documents and identify the issues. And Lior is going to talk about this more in a minute. But thanks to technology and AI, we're moving into a world where finding violations that were once inconceivable to discover is actually possible. Colgate proved the value in these cases exists. And now technology can help us find it systematically instead of accidentally. That's it from me. I'm going to now hand over to Lior, and he's going to talk about how we can actually find these violations and bring justice to the people who deserve it.
Thank you very much, Jordan. That was fascinating. The Colgate case is very interesting, and it was one of our most, it gives us the most motivation to do something that will be more scalable and makes the efforts to find those type of violation much more feasible. So I am Lior Strauss, and I have a PhD in computational biology and math. I'm senior data scientist in Darrow, and I'm in charge on the connection between the AI team and the legal team, and I have part in the creation of this specific tool that I'm going to discuss with you. So let's start with a short story. A few years ago, a huge company named Raytheon, she filed a new pension plan. This pension plan was around 200 pages, looks regular, but there was a single sentence in this pension plan that made this plan a violation. In this single sentence, they mentioned two things. One, that they are going to use a mortality table from 1971. And the second thing is that they are going to use an interest rate of 7%, that it's very high. So those two parameters make this pension plan a extreme violation, and it's one sentence out of PDF of 200 pages. This is why we are saying that basically reveal those type of violation is almost mission impossible. And why is it? If we are talking a little bit about the numbers, so in United States there are around 50K active pension plans. So if you, as a law firm, want to reveal one of those violations, you will need to hire an expert in ERISA and let him read pension plans all the day. Because the length of the pension plans, in average, it's about 200 to 300 pages. It will take him 2 to 3 days to read one pension plan, which means that in 1 year, he may cover around 100 pension plans. The odds to find in those pension plans a violation is very, very low, almost zero. So we want to do this process much more efficient. So basically, we want to make the impossible possible. So what we have done, we started with the assumption that not all the documents are born equal, which means not all the pension plans are interesting in the same level. Why is it? Because part of the pension plans are already sued, and part of them are too small to be sued. So we start by filtering out all the non-interesting pension plan, and after filtering, we had around 7K interesting pension plan. Yet, reading those 7K pension plan manually, it takes 60 to 70 years, and no one's in the world want or will do that. So the next part of technology was to do a very fast process based on AI that scan all the 7K pension plans, all the documents, all the pages, and try to give for each page a signal that point on the probability to have a violation in it. It's not an actual violation yet, but it's a signal for a violation. This quick process gave us two type of information. One, for each pension plan, it tells us if there is a potential violation in it or not. And if there is a potential violation, it focused us on the specific pages that may contain the violation. So from the need to read uh, 200 pages, now we need to read 2 to 10 pages per plan. So once we finished with this process, we created another process that made a deep analysis. This deep analysis gets all the context and all the pages that may contain the violation, and it gives back two types of information. One is gives us the information if there is an actual violation in it. It's not a signal anymore, it's a real violation. Second, and it's very important, during the process, the deep analysis is already creating the report that the lawyer need to convert this story into a case, which means when the algorithm is finished, it gave the lawyer all the data that he needs, and he have a minimal extra work to do after that to convert it into a real case. So once we finished this process, we ran it on all 7K. And again, let's talk numbers. We started with dozens of thousands of pension plans. We filtered out the not interesting and we remain with 7K. We did the signal analysis and we got 1K of plans that they have a signal for violation. Those 1K we processed with the deep analysis, and we finally got a list of 400 pension plans that they have an actual violation in it. And when I'm talking on a violation, I'm talking both on using all mortality table and a relative high interest rate. So we started from dozens of K and we ended with 400 potential cases. Our expert reviewed those 400 and he found that our accuracy is 0.98, which means only 6 out of those 400 were not an actual violation. It's very nice numbers. How much time it took us? All the process from the filtering to the final results, it took the algorithm around 8 hours of work. By doing this, we basically make the invisible, those type of violation, visible. And who is benefiting from this type of work? So first of all, and the most important, it's the employees themselves. Uh, Pension plans for decades include a violation. They based on their assumption that no one in the world can reveal them, maybe randomly, but not systematically can reveal those type of violation. So once the companies will hear about our tool, they will need to change their pension plan to not include those type of violation. Second, the law firm that want to sue those type of violation, now they have very strong, very powerful tool that not only give them the information which plan is included a violation, it's already give them a detailed report that help them easily to create a case. And third, and it's very important, the industry itself, because in the last few years, there is a lot of efforts to combine between AI and the legal world. And I think that here in Darrow, we're creating more than that, but this is very nice story that tells to the industry of the potential of combining AI and legal experts. So thank you very much for listening.
All right, thank you so much, Lior and Jordan. We're moving on to the question section. So I'm going to start with you, Jordan. From your perspective, how is AI actually changing what's possible for plaintiff firms day to day?
So that is a great question. And in many ways, this is more Lior's area, but let me set this up from a case perspective. I think the key is building systematic approaches to case identification and then kind of working out the potential value of a case or how big the violation is. And this is where the technology comes in. We're not looking for just one type of violation that might affect one specific person. We're looking for patterns of document implementation disconnects that might apply across heaps of different provisions and plans. And the AI that Lior talked about gives huge efficiency gains in discovering these violations with natural language processing and pattern recognition. And that means that instead of discovering violations by accident, we can proactively screen plans to identify issues. And then we can use the experts efficiently on what the most promising cases are. Of course, we're going to still need the lawyers and our expertise with understanding the law and being able to distill knowledge.
Mhm.
But this Colgate case and this technology shows that these cases can be worth potentially hundreds of millions of dollars. And I think that's really exciting.
So a follow-up on that, Jordan, would be, in your perspective, what makes Colgate such a transformational case? What about it?
Whoa. That, I mean, the first thing has to be awareness. Like
Mhm.
when you see a nine-figure recovery, that really gains attention. And I think before a case like Colgate, a lot of plaintiffs' attorneys might not have even known that this type of value was achievable with ERISA. And now they do. $300 million gets attention and it motivates all of us to look harder and also to invest in technologies and to build expertise.
Mhm.
But I think the second thing is probably methodology. Kind of sets out a bit of a blueprint. And we know now how these cases can work, what sort of documents we need to be examining, what data we need to analyze, and what type of experts we need.
Mhm.
And the fact that Colgate was such a document specific case doesn't really limit its transformative impact. I actually think it clarifies it. This wasn't one single statutory theory that we can just apply everywhere. This was proving that systematic document and data analysis of benefit plans can actually uncover massive value. And yeah, as I said, I think this is where technology can really help and bring huge, huge gains to the industry.
Cool. Jordan, thank you. Leo, now a question for you. What new data or statistical challenges arise? For example, if you're looking at health benefits, 401ks, or any other of those.
So I don't want to get into it too much details, but part of the plans, part of the documents are more difficult than others. In defined benefits, most of the plans are easy to analyze,
Hmm.
but we know how to deal with more difficult data. The starting point to get to extract the information from the plans, to instruct the information from the documents is sometimes harder, but we have the tools to deal with such scenarios too.
Cool. Well, last question, Leo, for you. What tools do you think made this kind of large scale forensic analysis possible?
So there is a huge trend today to use LLM
Mhm.
because I'm in this field for more than decade. I'm usually combined between traditional machine learning and the new LLM's abilities. And I think that the most exciting thing in our system is that it's combined the old and the new technologies. So together, it's something it's very strong, very reliable, and I think this is part of the reason that we got such a wonderful results.
Awesome. Jordan, Leo, thank you so much for joining today and sharing your thoughts and perspectives. And thank you to everyone who joined us. And we hope to see you again soon. Bye.
Pleasure. Thanks, Amit.
You.